Hi everyone. As we know that the DPDP Act is under implementation in India and the rules have also been notified by the government of India. And now it is just a matter of a time that the act will come into full enforcement in a very short time span. One of the important thing is in the recent time development is that the Ministry of Information and Technology, they have started the process for the appointment of the chairperson for the data protection board also. So you can easily understand the implication and the seriousness of the act. Now, in this particular lecture, we are focused only about the circumstances where you are collecting the data through your website under the and what are the implication under the Indian DPDP Act and DPDP rules. So as we know, most of the companies are collecting the data through e-commerce in the present digital age world or through their application, be it the e-commerce companies, or even if you are not a e-commerce company, you have a website which is an interactive website, then you are required to comply with the DPDP Act. Even if you have a static website, even that is within the preview of the DPDP Act, that therein also you need to comply with the Act. As I have discussed earlier, that Act was enacted in August 2023 and the rules were notified thereafter. And now the full compliance period is up to 30th May 2027. That is by this date, every company has to comply with this Act. So I'll repeat it again. There are four key actors for this Act. That is data fiduciary, like the website, like the company will be the data fiduciary, their website or the app operator that decides why and how personal data is processed. So they are the one who are the primarily accountable. For example, I give you, if any company is collecting the data through their application or e-commerce website like Amazon, or even if a company is not collecting the data, they are into the manufacturing sector and they have an interactive website or they are a listed company, even then, being a data fiduciary, they are within the compliance of the DPDP Act. They have to comply with the Act. Data principal is the one who is sharing his data, the individual who is sharing his or her data, and the data principal holds the right with respect to the notices, access, correction, erasure, and grievances. See, these are the all rights that are these are with the data principal under the DPDP Act. And the data processor, the vendor who is processing data on fiduciaries instruction. That means the any company's instructions. It may include your server holders, your cloud analytics, payments, gateways, marketing tech, anyone. But for any of the breach done by these data processors, data fiduciary will be the only one who will be responsible. So it is important that what are the bilateral contract between this data fiduciary and data processor with respect to the DPDP circumstances. Then the consent manager, as we have discussed in previous lectures and discussions also, that the process has been started by the government of India for the registration of the consent manager with the DPBB, and the it is the consent manager who can grant or who can manage the consent and who can withdraw the consent. Now, personal data is defined broadly any data about any an identifiable individual. Even technical signals qualify when linkable to a person. So if you are collecting the data, personal data directly or indirectly, so indirectly scope also includes and it also extends to the cookies also. Even although the DPDP Act nowhere specifically discuss about the provisions and about the circumstances and implication of the Data Privacy Act with respect to the cookies, but it is specifically there is a particular section and chapter into GDPR Act, but the interpretation itself clarify that the scope also extends to the cookies itself. So what you are collecting? आप collect कर रहे हो नाम, email address, phone, postal addresses, then the account transaction you are collecting, login ID, orders, payment preferences, history, technical behavior, IP, device IP, address, cookies, IDs, browsing path, location, scroll time on page, the behavior pattern, then the propensity scores, segments, wish list, cart abandonment, lookalikes. Then with respect to the child under 18, data requires a variable parent consent, and it is required under law that company is not entitled to broadcast any behavioral ads when it is the case of a child under 18 years. Now comes the important part, that is the notice and the consent mandate. So the notice, you have to give a notice, and it has to be in the it should not be within the your terms and condition. It should be very clearly visible on your website. Independent notice with respect to the what you are collecting. The privacy policy should be very clear, and it has to be in English language and other schedule language, that is the 22 schedule language. Then there has to be itemized list of data being processed, specific purpose for each item, that why you are collecting the data, means to withdraw consent, procedure to complain to the data privacy board if anyone wants to file a complaint with respect to the data breach or against any of the pattern of the data fiduciary. And when I say consent, it has to be free, no caution, and it should not be something when someone is visiting your website, if they are not agreeing with your terms and conditions, the only option they have that they have to leave your website. No, the DPDP Act is very clear about this. You cannot publish such sort of terms on your website or even otherwise also. And the data you are collecting, it has to be for specific purpose only. Whosoever is giving the consent on the website, it has to be very clear that what, why, how, who, and how long for which they are giving the consent. Then it should be unconditional and should not be tied to services, and it should be an unambiguous and clear consent. And the withdrawal of consent shall be as easy as for someone the process to provide consent. Now the important part is you cannot go with a system where you are displaying or publishing the terms and conditions on your website with already pre-checked boxes with respect to their consent. No, you are not allowed to do so. So the common myth is, as I said, the DPDP Act never mentioned cookies, also cookie banners are not required in India. And the reality is cookie that carry identifiers, profile users, or enable cross-site tracking process falls within the ambit of personal data, and so triggers the Act's full consent regime. And what is the meaning of this in the real practice categories? So essential, functional, analytical, and marketing. Then block first, no non-essential cookies fire before consent. Only the required for the required purpose you can collect the cookies, and thereafter the pre-category opt-in. As I said, you cannot provide any such of option that either you accept it or you leave the website. Then the audit logs should be maintained, time-stamped, version consent records. Security safeguards as defined under Rule 6 of the Data Privacy Act. Encryption. Reasonable security safeguards are the mandatory at a minimum. Failure to comply with the Rule 6 may attract a penalty that may extend up to 250 CR. So the encryption of data, mask or tokenize or tokenized data, and this process has to be done in transit as well as in storage in order to protect the personal data of individuals. Then the access control. The access of the data with respect to the operation should be very limited. Role-based access should be given. It should not be the random access to everyone. And least privilege access to systems holding personal data. So you have to make sure that the control and access with respect to the systems through which you are taking the data and through which you are processing and where you are storing and processing the data, it should be something which should be within the parameter of the act, and you have to ensure a high amount, a very high a privileged access to systems, and it should not be for anyone and everyone. Then the monitoring. The logs, alerts, review to detect and investigate unauthorized access should be there. The log retention for at least whosoever has logged into the data, into the systems and data, it has to be stored for 1 year after processing. Then the backup you have to maintain, and after for the purpose of the data recovery in case of a breach also, and therefore a company or the data fiduciary is responsible to ensure that data is being stored at the multiple places. So when there is any incident of data breach, it has to be reported to the data protection board as per the act and in compliance with the rules. Then, as I said, that you have to ensure equivalent safeguards into vendor agreements. As I said, for the act of the vendor, it is not the vendor who is liable, but it is going to be the company that will be liable for the act of the vendors also. Breach notification protocol. Supposedly, there is any case where there is a data breach and someone has logged into the system, or some sort of a virus has been placed within the system which resulted into the data leakage, then without any delay you have to inform to the data protection board, and within 72 hours you have to place a detailed report of the breach circumstances and the personal data and principals affected. It is also required that you should inform everyone or every individual whose data has been compromised. They should be also informed, and what are the action you are taking with respect to this data breach. Now, you'll see the important aspect is number one, you have to inform to the victim also, like in this case will be the individual who has given his or her data to the company. But the most important aspect is that when you are filing any such report with the data protection board, or even if you haven't filed, anyone has filed a complaint against you before the data protection board, the first thing a board will verify that how much you are in compliance with the act. So therefore, the compliance of the DPDP Act is not an option. It is something which is a mandatory requirement, irrespective of the size of your organization. Then the retention, erasure, and significant data fiduciary. So erase data when purpose is served, or withdrawal of consent. Or if someone is withdrawing the consent, then you have to erase the data. There is a 3-year cap for large e-commerce, gaming, and social media intermediaries that they have to store this data for this period, and thereafter, after 48 hours notice, they can erase the data. And then retain only what law independently requires. If there is something which is required under any independent law with respect to the storage of data, then you have to retain up to that extent only. And when I say the significant data fiduciary designated by the central government are those companies who are collecting the data in very large amount. And to give you very rough and raw example, like Amazon, Myntra, these are the significant data fiduciaries, or companies like Practos who are collecting the data. And for them, it is required to appoint a data protection officer based in India. Then they have to comply with annual independent data protection audit also. Then they have to comply with the periodic data protection impact assessment also. Then they have to also ensure that fairness assessments wherever it is applicable. When it comes to cross-border transfer, Section 16 permits transfer of personal data to any country except those that is barred by the central government. And the key obligation is that for any such breach, the fiduciary shall remain responsible for the violation of the act. In case of child and person with disability, so you have to make sure as a data fiduciary company that that verifiable parental consent before processing any data of minor. This means that it is the obligation of you to verify who is giving the consent is whether authorized under law to give so. Is it someone who is legitimate parent for the particular child or the person with disability? Then you cannot track the behavior pattern of the child with respect to the his digital movement, no targeted advertising to child, and then equivalent consent regime for person with disability also. So, what companies must change when it comes to the DPDP Act, and when we are discussing about the case where you are collecting the data or you have a website, then first thing you have to do, you have to map the data, audit every personal data flows, that how you are collecting the data, through which source you are collecting the data, and the location we are staring, where you are storing the data, for how long you are retaining the data, and who are the people who are having access to this data. Then the other important aspect is notice and consent. You are required to rewrite your privacy notices as per the DPDP Act. Then you have to deploy the multi-language notices and the consent banners. Then you have to uplift your security. You have to comply with the encryption. Then there are SIEM monitoring, RBAC, MFA, BCP/DR, then vendors data processing agreement. So all these things you have to do. In short, a company is required to revise its security measure when it comes to the data privacy. Then there is a automated retention rules, and you have to delete the data by giving notice to the other party, and you have to comply with it. As I said, for the significant data fiduciary, it is mandated to appoint data protection officer, and to you have to go by the data protection impact assessment every year. And then with respect to the vendor and cross-border data, you are required to renegotiate your data privacy agreements also, and you have required to map and document all cross-border transfers. As I said, the penalty for the breach that starts from 50 crore and it extends to 250 crore. And for the all such act, it is the data fiduciary will be responsible. So for the first 3 months, you need to stand up the DPDP working group with legal, IT, marketing, HR. Then the personal data inventory forms, cookies, vendors, cross-border flows, gap analysis against act rules, and they identify the significant data fiduciary risk. Thereafter, you need to rewrite and comply with the act by rewriting the privacy policy, build multi-language, then granular consent UX, and the implement rule 6 controls, encryption, RBAC, logging monitorings, renegotiate vendor DPS, document cross-border safeguards. And then how you have to defend is to roll out retention erasure automation, 48 hours notice workflow, test breach response, and then train your staff with respect to the DPU. So it is not something that you will decide with respect to the compliance of the DPDP Act. आपके ऑर्गेनाइजेशन डिजिटल फॉर्म में कोई भी डाटा कलेक्ट कर रही है, उसका सबसे पहला इंटरफेस ही आपका वेबसाइट है या फिर आपका एप्लीकेशन है। तो आपका वेबसाइट और एप्लीकेशन फर्स्ट ट्रिगर पॉइंट है जिसको डीपीडीपी एक्ट में कंप्लायंस होना पड़ेगा। उसमें सबसे इंपॉर्टेंट पर्सपेक्टिव आ जाएगा कि आप जो डाटा कलेक्ट कर रहे हैं आपको उसको रीथिंक करना पड़ेगा, कितना रेलेवेंट डाटा आप कलेक्ट कर रहे हैं, क्या आप कलेक्ट कर रहे हैं प्रेजेंटली और क्या इस पर एक्ट कलेक्ट कर सकते हैं। सेकेंडली, आपकी जो कुकीज की पॉलिसीज हैं वो भी आपको डीपीडीपी एक्ट के हिसाब से रीकम्प्लायंस में लानी पड़ेंगी। थर्ड, आपको नोटिस, प्राइवेसी नोटिस आपको रिवाइज करने होंगे और नोटिस को भी आपको इन कंप्लायंस विद डीपीडीपी एक्ट लाना पड़ेगा। एक क्लियर कंसेंट मैकेनिज्म डिस्प्ले पे लाना होगा, एक क्लियर विड्रॉल कंसेंट मैकेनिज्म आपको डिस्प्ले पे लाना होगा। Then the very clear information with respect to the grievance officer or and the data protection officer. And the most important aspect is कि आपका जो डेटा कलेक्ट हो रहा है उसकी सिक्योरिटी एंड इंक्रिप्शन सिक्योरिटी के रिगार्डिंग आपके प्रेजेंट डे कंप्लाइंस क्या है एंड एज पर द एक्ट आपके क्या कंप्लाइंस होने चाहिए। So this is just a insight on how you have to comply with the DPDP Act and how it is something which is directly impacting the business for any organization.